Thanks to Bill for making fish kill seem interesting. So certainly appreciate that. Our last panel before our discussion, before our break this morning, is Steve Whitworth, who is the Director of Environmental Services at Ameren. And not surprisingly, we're going to revisit the issue of greenhouse gas regulation on electric generating units and kind of a status update of where are we now. And certainly we look forward to your comments. So the floor is yours.
Good morning. Well, I try to get moving through this a little bit and realizing that I'm between you and your break, but appreciate your patience. And just I like the last presentation, and I mentioned the study things. I like to think of that, the 316B rule is now it's the Biologist Reemployment Act of 2014, previously 2012, previously 2006, but kind of interesting stuff as we move forward. I like presenting at this conference, and I appreciate the opportunity to do it again. I think this is one of the cooler rooms that we've been in, so kudos to the group for getting it this way. I'm going to tell you a little bit about how we're seeing the regulation, a little bit overview on Ameren to put things in perspective, a little bit of background on CO2 regulation and regulation of greenhouse gases under the Clean Air Act. And then hit some high points on the new source performance standards, both so we have three rules, the new unit rule, the modified and reconstructed unit rule, as well as the existing source rule. And then trying to get some perspective in from kind of the Ameren point of view and some things to think about, I guess, from my perspective as we go through the comment period. So Ameren's a company, investor-owned utility company, fully regulated now as of the end of last year. We had a merchant business that we've generally divested, so we're entered into a fully regulated entity. We have several different operating divisions, natural gas and energy delivery regulated company in Illinois without generation. We have a vertically integrated utility, Ameren, Missouri, with generation. And I'll talk a little bit about our generation mix from both the actual energy perspective as well as a capacity perspective. And then we also have about 3 million customers, about 2.5 million electric customers, and about 900,000 natural gas customers. And as you mentioned, or as you notice, we have some hydro. We have what we call ultra-low sulfur coal, PRB, on the low end of the SO2 concentration, natural gas, nuclear plant at Callaway in Columbia, Missouri, and landfill methane. Most recently, we just kicked off a 6-megawatt solar project, which is one of the larger projects in Missouri that we're moving forward with. As I mentioned, the business structure, I'm in the services company. We have a FERC-regulated transmission company, as well as Ameren, Illinois, the energy delivery company, and Ameren, Missouri, which has generation as well. So here's kind of a mix of our generating assets, and we do have renewable, some purchase power agreements for renewables, mainly wind in northern Indiana, a little in Illinois, a little bit in Iowa, and looking to move forward on additional assets in that regard. But the majority of the generation, both coal, some natural gas-fired peaking units, a little bit of oil-fired units, which don't see much action these days, and then Callaway. We also have a run-of-the-river hydro plant up at Keokuk on the Mississippi River, and was actually built for the 1904 World's Fair in St. Louis. And then we have Bagnell Dam, which, if you've heard of Lake of the Ozarks, a rather large lake in central Missouri, and a hydroelectric facility there. A little bit about our fuel mix. So I put up Ameren, Illinois, because Ameren, Illinois still has to buy power on the market and provide it to the customers. So it's a little bit of an interesting concept here in Illinois where generation is deregulated, electric service is actually still regulated. So the operating company has to, buy power on the market and then get rate recovery that's regulated by the Public Service Commission. But still, even though there's a lot of nuclear generation in Illinois, our mix, and these are based on 2012 numbers, we're about still 60% plus or minus coal-fired generation. The difference is there in the middle between our generation capacity mix, which is about 25% natural gas, compared to the right circle, which is actually our energy mix in 2012, which was about 73% coal and about 24% nuclear, which is our Callaway plant. A very small amount of natural gas. So even though we have natural gas capacity, it doesn't run as much based on even with natural gas prices, because most of these units are peak or simple cycle combustion turbine units. And so when we get to the point of where EPA has determined what these state goals are and how the baselines were calculated, and I put 2012 up here because that is the baseline that's being used for the existing source greenhouse gas rule. Whoop. Now I got happy on the clicker. There we go. All right, working good. So a little bit of background on CO2 regulation under the Clean Air Act. So the Supreme Court upheld several years ago, I think 2007, in a court case, and not being a lawyer, I'm not going to get into the details, but really the precedent was that CO2 emissions and greenhouse gas emissions can be regulated under the Clean Air Act. And that's really kind of changed, I think, the context in which EPA now is moving forward on regulations versus several attempts over the years on, a multi-pollutant type approach, a 3P that included carbon, or a 4P type approach that included mercury back at that point in time. We've moved forward with regulations by EPA both for mercury, for SO2 and NOx, and now looking at greenhouse gases as well. The endangerment finding really set the stage. So EPA, once they had the authority under the Clean Air Act clarified, were able to move forward, and the endangerment finding basically said that greenhouse gases constitute both a threat, air pollution that presents a threat to both the environment and human health. And it also establishes a format where EPA can move forward with regulation. EPA had this issue since they could regulate greenhouse gas emissions under the existing prevention of significant deterioration rules that have emissions thresholds set for what constitutes a modification or what sources would have to meet best available control technology standard. Those levels were essentially very low, and if EPA applied that to greenhouse gases, predominantly CO2, we'd have a whole host of small emission units that would be covered by the Clean Air Act. So they came out with the tailoring rule that took effect in 2011 that really set higher thresholds for what constitutes modification. And there's actually a Supreme Court heard a case regarding EPA's authority to regulate under the PSD program and the Title V permitting program. And as I know, the decision, I think, is expected any time now, but I don't think it's been issued to my knowledge. But that will actually make another, maybe a little bit of a landmark determination on how EPA can regulate. So we could have a dilemma where EPA may not be able to regulate CO2 or permit it and this significant threshold concept, but still moving forward on actual emission limitations for affected sources. And then a year ago in June, the President released the Climate Action Plan that included a goal of kind of I think it was the same goal that was in Waxman-Markey back a few years ago in 2008 timeframe, of a 17% reduction of CO2 emissions from a 2005 baseline by 2020. Okay, so we have the new source performance standard context under the Clean Air Act, and this has been used to set emission limitations for sources typically based on a date certain, so a unit that's constructed or for which construction starts after a date certain. You're probably aware of the current Subpart DA limits that have particulate matter, NOx, and SO2 limits. So EPA back in 2012 had proposed a regulation to set an output-based emission limitation in terms of pounds of CO2 per megawatt hour output, which takes a form similar to some of the newer DA limitations in the basis for NOx and SO2 as well. That rule, under the Clean Air Act, there's a statutory limitation on EPA has a period of time, approximately a year from proposal under the new source performance standards to finalizing that regulation. So EPA did not finalize the first version of the proposal, and then in last June, as part of the President's Climate Action Plan, he basically set a deadline for EPA to release a revised or a new proposal for new sources. We got that rule released on September 20th last year, which was the actual President's deadline. I find it a little bit curious. The rule was actually published in the Federal Register on January 8th of 2014. So I'm going to mention this in the context of a couple things moving forward with the existing and the modified reconstructed rule. So it takes, and we just mentioned in the last presentation that the final 316B rule was released back in May, like May 16th. Still hasn't been published in the Federal Register. So you have this time period between actual release, the unofficial version, if you will, and then the official version that's published in the Federal Register. EPA extended the comment period that closed on May 9th and are currently considering numerous comments that they've gotten on the appropriateness of the standard. And under the Clean Air Act, under Section 111, which sets the new source performance standards, as you've probably heard several times, the federal programs are set for new, modified, and reconstructed units as defined under the Clean Air Act and the regulations under Section 111B. And then there's also a really seldom used provision for existing sources, which I think has been used probably 3 or 4 times historically under Section 111D. So as EPA moved forward with the reproposal of the new source rule under 111B, they proposed a limit of 1,000 pounds of CO2 per megawatt hour. There are a couple different averages that were proposed averaging times, I think a 12-month and an 84-month averaging time period. But they really there's this concept of best system of emission reduction, BSER, yet another acronym in the air quality world. And they essentially have set carbon capture and storage as BSER, best system of emissions reduction for a coal-fired unit. They also set a limit for natural gas combined cycle units, and they set a range of either 1,000 to 1,100 depending on the unit size and how they were utilized. One thing to remember as we move forward on this, there's a statutory requirement under the Clean Air Act that EPA has to have a new source performance standard set for a new or modified or reconstructed unit before they can move forward with an existing source regulation. And so EPA has a standard, and it was brought up a couple times yesterday, as far as they need to get either the new source performance standard for new units or for the modified existing units, or reconstructed units rather, promulgated and in place before they can technically move forward with the existing source rule. And at the same time, they're moving forward on 3 different fronts now. There we go. So under the little bit finer print, but there's 2 more regulations that are coming out. So as we've mentioned, the EPA has set this, there's this concept of adequately demonstrated technology and whether or not carbon capture and sequestration is adequately demonstrated to be used and relied on under the new source performance standards. Having that challenge, EPA is also moving forward, and I think they had a consent with environmental groups on moving forward and proposing a rule for modified and reconstructed units. And those triggers, reconstructed as a cost basis on replacement cost of the unit. Modification would be whether you made a significant modification to an emission unit triggered by a significant increase in emissions. And as most of you probably know, the industry has been challenged under new source review provisions, and there's an ongoing question and lots of legal battles, if you will, around the concept of what constitutes a modification. But EPA has proposed this regulation, and actually both the new source performance standard for existing sources and the reconstructed and modified sources were released on June 2nd. They were actually published today in the Federal Register for a public comment period. So the public comment period officially starts today. The comments end October 16th. And I mentioned before where we had this lag of several months on the new source rule between September and January. EPA got this one turned around and in the Federal Register in 2 weeks. So I don't know what everybody thinks about that. I think that is a sign of, that they really want to move forward on this rule. They have a tight time frame, and they really expect to meet this final rule deadline that they've been set or, challenged with by June of next year. The concept under the modified units and reconstructed units is a similar output-based limit. And I put the range up here, 1,900 to 2,100 pounds of CO2 per megawatt hour, which isn't really too far off, from the existing fleet on new units. And then a similar limit of 1,000 to 1,100. I think under that proposal, they have a broader range that they're accepting comments on. And they've broken those two limits in both cases on the types of emission units. So they've broken out essentially coal units from natural gas units, and then they've set a megawatt output capacity limit on addressing which units would meet each standard. So again, this concept of best system of emission reduction really based on unit-specific pound per megawatt hour output-based emission limitations. In the case of 111D, which is the existing source rule, EPA has defined best system of emission reduction as a state-specific goal in terms of pounds of CO2 per megawatt hour basis. And EPA has been very clear in this case that it's based on net generation, not gross generation. So when you look at this from a little bit how EPA calculated these state rates, typically all of these emission limits on existing electric generating units, even if they're an output-based limited based on gross generating output, are essentially the energy produced by the emission unit and that process. In this case, EPA is purposefully looking at net generation, going out on the grid essentially. We can talk about why that might be, but it does kind of tighten things up a little bit. They set 4 building blocks that were discussed yesterday a little bit, and a couple things I think are important. We're still getting through this regulation. We've got a 120-day comment period. There's going to be several public hearings, lots of interchange going on. But trying to understand this rule, EPA has set guidelines for the states to use, and the states have to come up with their regulations. And the time frame is final rule from EPA in 2016. The states have a year, 2015 for the final rule from EPA, 2016 for the state rule. They've also proposed the states can get a year extension or a 2-year extension if they enter into a multi-state trading program. And so the one thing I think that's interesting about this, even though EPA has given us these building blocks for the states to use as guidelines, they've kind of opened the stage a little bit where states can do some other things and work with adjacent states. They've also mentioned that some of the programs that exist, like the RGGI trading program in the Northeast, would qualify under this proposal. And EPA has set these state pound per megawatt hour limits. They also mention that you can do a pound per hour or a mass emission, not pound per hour, mass emission, tons per year type approach. However, they don't really give you guidelines on how to calculate that number. And I'm punted a little bit on how to move forward. So when you think about the trading programs, some cost to carbon and dispatch and things, it'll be interesting, I think, to how things move forward and how states are going to view this, whether it's emission rate or mass emission. You still have to have mass emissions in the equation, even if you calculate a rate. If you have a multi-state program, it's going to be even more complicated moving forward. EPA, I think, and the states are really going to be challenged with developing these regulations as they move forward because it's really setting energy policy. So I know in Missouri, Department of Natural Resources has a stakeholder meeting set for July 14th. I think they know they've got a tiger by the tail, but their stakeholder group is going to be much different in this context than it typically would be for an air quality regulation to develop an SO2 non-attainment plan or something along those lines. So you're still going to have the state, air pollution control agencies developing these regulations, but the playing field, kind of the sandbox of who all the players are is going to get much bigger. The other thing under the building blocks I wanted to mention is EPA provided these 2012 baseline and really are talking about credit for prior emissions reductions not being allowed. And so I think that's another piece of this is how that's going to play. If you don't make reductions until maybe 2019 or consideration for reductions made until 2019, how are you going to continue in this context of moving forward with the several different things that we have to look at? And just a kind of a commercial, and everybody's aware of this, but it's not just about the greenhouse gas regulations. When we're talking about what our compliance scheme is going to be, 316B for another example, 2020, 2022, ultimately determining what our control technologies, what modifications you might have to take to your intakes. That's the same time frame when you have to start complying with these greenhouse gas regulations. We have the MATS rule, we have future rules on effluent limitations, so it is a balancing act with uncertainty, and how do we mesh all these things in a, and now we've got the greenhouse gas rule, which is kind of the 800-pound gorilla in the room, if you will. We need to keep energy affordable and reliable and responsible all at the same time. So just another, I guess, comment from my perspective on the balancing act that we're faced with as we move forward to determine what's the best approach and how the states are going to balance this equation. Just a mention, one of the things that is touted by EPA in the proposal for greenhouse gas emissions is reductions in SO2 and NOx. And the same approach was taken in the MATS rule. This is just a view from our fleet perspective, looking between 1990 and 2012. And I know the rest of the industry is kind of in the same boat. But just to put things in terms of concept, there have been a lot of reductions in SO2 and NOx. And moving forward, we've also seen reductions in CO2 emissions. So things have been moving forward for a lot of different reasons, economy, price of natural gas, aging infrastructure. I think the industry realizes that everybody is moving towards a cleaner approach, but how you get there and how quickly you have to get there really is going to take some very thoughtful process moving forward, and we can't just jump into something not considering all the other impacts. I mentioned that EPA has asked for the states to develop these regulations. An example in Missouri, when you talk about generation, we've got 2 different ISOs. We've got some co-ops and munis that have isolated systems. So the concept of the state actually taking over or having some control over dispatch order really doesn't seem to me like it's going to fly. And how these things are going to get with this statewide emission rate. How do you balance the equation, and then how do you move forward with the other interrelation pieces of that? I think there was the commissioner from Michigan showed the MISO footprint and how it's broken into zones. And so that's, to me, a good example of looking at an interstate trading program. There are a lot of factors to be considered on how that might manifest itself. The other thing I wanted to mention on here, just as something to keep in the back of your mind, is the social cost of carbon. There's been a lot of work going forward and how the social cost of carbon is determined. It hasn't been used to justify this regulation, but it has been used in a lot of different contexts. There's a lot of work going on behind the scenes. There's some very complex modeling, but you go back to the devil in the details, that there are a lot of assumptions and things that are plugged in, and you get a cost spit out of $37 a ton for that next ton of CO2 and what those impacts are. So there's a lot of debate moving forward, and another thing that we need to keep track of as we move forward. So in closing, I think we've got a large challenge ahead. I think in a year from now, when this conference comes back, we'll have some more discussions on where things went and be awaiting what EPA's final rule is. And then certainly this is going to be a multi-year process as we move through with our own states and trying to get the balance between what can we do to clean up the fleet, if you will, and keep moving forward in a reasonable and balanced approach. So thank you, and I'll try to answer any questions if we have a couple minutes.
Thanks, Steve. Any questions from the audience?
This has to do with building block 1 for existing units under 111D, which encourages heat rate improvements. It seems like those same heat rate improvements, though, would make the unit a modified or reconstructed source, and thus it would move it from state regulation under 111D to federal regulation under 111B. if you spend that much money to make the significant heat rate improvements that are encouraged under that building block. Your opinion on that?
Yeah, I don't disagree with you. And one of the, when EPA went through the stakeholder process last fall and had all the listening sessions, that was one of the messages that, at least from the utility industry, was that there needed to be some considerations from a new source performance perspective and new source review to deal with those types of efficiency improvements. And there have been ongoing challenges for those types of projects that have already been completed and have, helped minimize emissions and reduce the emission rate. And how those will be considered in the future remains to be seen. But I think that's going to be another issue that potentially looms large. And just another comment related to that, I mentioned the source category list. So when you think about new units, and it applies to steam electric generating units as well as natural gas combined cycle, the other catch is that if you build a new unit or maybe you repower an existing unit, there's a question of whether or not that improvement or reduction in your carbon footprint and replacing that generation with new generation, whether that could be counted towards your state goal or not, because it would potentially qualify under the 111B categories of new, modified, or reconstructed in lieu of an existing source.
So did they indicate that they're going to provide any more clarity on that or any relief on new source review?
I haven't heard anything directly from that, but I know there are ongoing discussions with EPA from, a number. I think there's, even today, there's a meeting with the EEI group and EPA to try to clarify and get responses to a lot of questions that we have related to what EPA is thinking and how that's going to, roll out in a final rule. All right. I think that signifies break time. Thank you.
Thank you, Steve. Appreciate it. We will reconvene at 10:50.